Hi, everyone, and thank you very much for joining our webinar today. The topic of discussion is proposed revisions to the PRC arbitration law. What's new? To those of you who have been following this development, you would know that the proposed amendments came out a year ago, so we're just past the 1-year anniversary. The proposed revisions haven't been enacted yet, but throughout this year, there have been a lot of excitement with commentators looking, studying at these proposed revisions, because this is the first time that the PRC arbitration law has suggested any major updates since its promulgation in 1994. So today I'm delighted to be joined by leading arbitration lawyers who would discuss what these proposed revisions are and what changes they may bring. So with us are Arthur Ma, a partner at Dahui Lawyers, Xianglin Chen, partner at Hankun Law Firm, Chi Wei, associate at Quinn Emanuel. Chi was also previously a counsel at HK45. My colleague Ran Chen at Langyue Law Firm. And finally, I'm Joanne Lau. I'm a partner at Allen & Overy. So we have prepared some slides to guide our discussion today. So could I trouble Jade to share that? Thank you. And on to the next slide. Yes, so on the outline, let me just tell you all what we'll be covering. So broadly 5 topics. One is on foreign arbitration institutions. Topic 2 on jurisdictional challenges. 3, interim relief and emergency arbitrators. 4, enforcement, which always attract a lot of interest, and finally, looking ahead. Because we would welcome questions throughout the webinar. So if you do have questions that you want to pose to the speakers, then feel free to use the Q&A function at any point in time. So we'll either address them during the discussion, or if we have time left, we might address it at the end. And what we've done with these slides is when we turn to each of these topics, we'll also show you the proposed revision. So we've extracted them onto the slide so that it's clearer for reference. So with that, let's turn to the first topic, the next slide on foreign arbitration institutions. So let me just give a very brief background. This slide shows Article 12 of the proposed revisions. People were very interested and excited about this because this is, I think, the first time where foreign arbitral institutions are recognized and referred to in the arbitration law. My first question would be directed to Arthur, because clients often ask, say, if they have a China dispute or if they want a seat in mainland China, can they still choose a foreign arbitral institution? So Arthur, any views on that?
Well, thank you, Joanne, for raising the question to me. I would be very glad to share my thoughts about this issue with the audience. Well, I think it has always been a very exciting topic to see how the Chinese, if we're looking at the arbitration institution as a service industry, to see the market access, how the door is gradually open to the outside world, because we have always we have in mainland China the most arbitrating commissions in the world. I can say that we have over 250, but the institutions worldwide acknowledged as leading ones, such as the ICC, HKIC, of course, SIAC. How are they allowed to participate in the arbitration domain in mainland China has always been an area that attracts lots of attention. So if we are looking at this amendment, well, of course, this is not the final version. We don't know how and when the finalized version would be. But at least if we look at the terms on the screen, I think they're really substantive development compared with the current status. For example, it used the word 业务机构, so it's operational institution, and then it said so they can conduct foreign-related arbitration business. I think this is a huge change. This is a huge leap forward. Why? Because at the moment we know, at least in Shanghai, we have the ICC representative office, HK45 rep office, and also SIC rep office. But I don't know how many of the audience have visited their offices. It's largely a post office, rep office for these institutions, mostly to do marketing in mainland China. They don't have the capacity like a secretariat. They don't have staff to handle the submissions, the papers, the evidence. They don't have a staff team to actually arrange in mainland China all these logistics issues. It's largely just a representative office handling marketing issues. But if we eventually have this Article 12 to be effective, that means what? That means the door is open much wider, because these institutions, I'm only referencing to the three, there are many more, they will be allowed to actually establish a substantive presence in China, and they can do operational work. They can do business, meaning they can directly accept a case. For example, if now we want to file a case to HKAC, you post it to Central in Hong Kong. But later on, if you can do business, you have a staff, secretaries, legal counsel based in Shanghai, you directly serve the documents to the Shanghai Post address, and they will accept the case, and the whole proceeding will kick off, will commence. And that, I think, although some may say, well, not much difference, I think it's a huge difference, because later on the market landscape will be different. Now, still you have the mainland commissions dominating the market, but later on you will have competitors, and they will do the same administrative work competing with you. And by then, the parties, they will have more options. They will say, oh, I prefer to have this case heard by HKIC, of course, subject to latest legal restrictions. But then I think the domestic institutions, they will feel pressure. They will provide better services to attract, to maintain their clients, because the end users, they are the clients of the agency in a sense. So I think this, if we have the Article 12 promulgated as part of the law later on, I think that will make a huge difference in the Chinese arbitration service market. So that's the first point I want to make. The second, I'll finish really quickly, is that we must remember, we must not forget that arbitration law is actually a procedural law. And it is not operating by itself. It is operating as part of the whole body of laws governing arbitration in mainland China. We still have the substantive law that used to govern what kind of disputes can be submitted to foreign arbitration institution. For example, everyone remembers Article 128 of the contract law, which was the foundation, was the basis when parties, when they are involved in a foreign-related case or with a dispute that has a foreign element, they can submit the case either to foreign-related institutions, commissions in China, or they can submit it to other, as the wording went, other arbitration institutions, which was interpreted as institutions outside of China. But interestingly, we are now in an era of the civil code. Now we have bid a farewell to the contract law. The contract law is no longer valid after the civil code entered into force last year. So where is the replacement of Article 128? if you check the civil code, you will be surprised. There's no replacement of 128. It's gone. It's gone. But does that mean this restriction that only disputes with foreign element can be submitted to foreign institutions, is that restriction also gone? This is actually a real question, because before you have contract law, now you don't have it. We've done some quick legal research, and we found Chinese courts, at least the cases we saw, they maintain the same mentality as before. There was one case, for example, in Tianjin, which was ruled in 2021. There was two domestic legal entities that had a dispute over some subject matter, also domiciled in China. And then the court said, oh, I'm sorry, there's no legal basis allowing you, two Chinese entities without any foreign element, domestic disputes, domestic subject matter, to direct the dispute to HK45. They still use the same standard of foreign element to be the one to be the key to whether you can open the door to foreign institution arbitration. I think this is really critical, because without a really clear legal authority on this issue, saying that, the previous standard under contract law article 128 is no longer valid. We've abandoned that restriction. Now, as long as the parties, they are willing to appoint a foreign institution who has presence in China based in this on this article 12, you can go with it. Unless I think we have a clear authority from perhaps Chinese legislative authority or from the SPC. I tend to be conservative that the door is still not fully opened. I think perhaps the same standard of foreign element would still apply, even if we have institutions like HK45 have substantive presence in mainland China. But as to when we can have a very clear answer to that question, at the moment, I don't have the answer. I don't know, because it will be a really substantive change of the whole arbitration system. For that kind of change, I think, based on my observation, the change has always in China has been graduate, step by step, little by little. It's not such a huge change. So I think of course, I welcome Article 12. I hope all the colleagues, all the international institutions, colleagues can join the force to build a greater arbitration community of really high standard. I'm not saying the current standard is low, but it's a unified service standard. But still, it's my observation that still we're bound by I can't say the ghost, the remainder of Article 128. Now, no longer, you can't find it in civil code, but still foreign element, I think, would be a key issue if you want to bring the case to foreign institutions. I'll stop there.
I see. So even if with this change, foreign arbitral institutions can now start administering cases from China, the conservative view would be that it still needs to be a foreign-related case.
That's the conservative view. I think that's the conservative view.
Yeah, and maybe could you just remind the audience what foreign elements are? What would be considered foreign-related for those who maybe like?
Definitely. Well, foreign elements has always been a key area. First appeared in the interpretation of the civil procedural law. And then later on, when we have the 涉外民事关系法律适用法, which is the Chinese conflict of law rules, we also have a short list of 5 situations. Basically, you can think of the party's identity, the subject matter of the disputes, the facts that create or change or terminate the legal relationship, and later on we have, for example, for individuals, a natural person, you have your domicile, whether it's domestic or outside mainland China, and then there's a cover-all term in that short list. And other situations, although in practice it's quite seldom actually to see that the court would apply the fifth standard to say whether it's a foreign element. By the way, Joanna, I just forgot to mention that I should mention that for free trade zone, still it's from 2016, and later on the SPC's reply, entities registered in foreign trade zone, free trade zone, domestic, if they are submitting their disputes to a foreign institution for arbitration, the law is saying that the current rule, and it's not law, the court cannot deny the validity of the arbitration agreement simply for the reason that the parties are registered in China. So that has been a topic for a while after the SPC and the Shanghai, the free trade zone area. I think first Intermediate People's Court in Shanghai to announce that rule. So that was the exceptional situation to supplement the whole picture.
Yeah, so the door is increasing wider and wider, step by step.
But step by step.
Yes. Maybe let me turn to Chi now, because Arthur also touched on how there are already many institutions like ICC, SIAC, and HKIAC specifically who have already set up offices in China, even though they do mostly business development activities, but it seems to me they are well placed to also start explore these new developments. And I know you were previously at HKIAC too, so I'm interested in your views. Could you share what do you think would be the practical challenges for foreign arbitration institutions to administer proceedings either in China or with the mainland China seat?
Okay, thank you, Joanna, for the question. And I totally agree with what also said. I think it is a step-by-step process. And actually, currently, there are some cases in mainland that allow a foreign institution to administer seat with PRC as a seat. But however, in practice, these kind of cases are very, very rare. I have administered over 200 cases at HKIC, but none of them is with mainland as a seat. And I think the main reason, the main difficulty for us or for the lawyers to recommend a foreign institution plus a mainland seat is because there are some major inconsistencies between the current PRC arbitration law and the institution's rules, like the SIAC rules or the HKIC rules. And I can give some very typical example. For example, the first one is about the doctrine of competence and competence. Under the current PRC law, a tribunal may not be able to decide its own jurisdiction. And I understand like Xiangling will give more explanation later. And a second one I want to point out is about the constitution of the tribunal. Like under the HKIC rules, if the parties, they cannot reach an agreement on the presiding arbitrator, then usually the two co-arbitrators should designate the presiding. But under the current PRC law, it should be the institution to designate the presiding arbitrator. And also there are different requirements about service, about delivery, like the PRC law, it provides the arbitration institution has the responsibility to serve the notice of arbitration and answer on the parties. But under the HKIC rules, it is the party's responsibility to make sure all the papers has been duly served. So actually, this is one of the major difficulties our PRC parties have once they are doing international arbitration. They usually rely on the institution to do the service for them. So these are also the interim measures, and a lot of other procedures are different. So a question would be like how to handle this difference. But the glad news is because of the new amendment to the PRC arbitration law, a lot of like this kind of inconsistency has been lifted. Because one of the reason is all the institution rules, they are based on the ancestral rules or ancestral laws or the model law, but China is not a model law jurisdiction. But one of the goal to revise the current arbitration law is to adopt some good provisions from the ancestral model law. So I expect after the adoption of the new arbitration law, there will be more and more cases for the foreign institutions to administer. But I think there will also be some remaining issues. Like one issue is like Arthur just mentioned about the foreign element part. This means the foreign institution maybe need to assess whether a case meets the foreign element standard. And also there are some other provisions that is different. Like one key one is about the criteria of arbitrator. Like for HK45 arbitration, you can pick whoever you want as long as there's no conflict. But under the PRC laws, there are some specific requirements on the criteria of the arbitrator. So what if I choose HK45 arbitration, seat China, but I choose the arbitrator that does not meet the requirement on the PRC law? Is he a valid arbitrator? If he rendered an award, can I reject the enforcement of the award? So I think there are still some remaining uncertainty. And I want to add one minor point. It's about HKIC service in mainland China. So actually, although now we only have a representative office and doing business, but actually they also provide some part of the arbitration service, such as holding hearing or yes, that is the main service. And also for cross-examinations, they can provide some help. I think the main reason, there's another like key reason there's no forced staff in mainland China is because not everything is online, and you can administer cases from the Hong Kong's main office because you don't need to submit a paper notice of arbitration answer. You can submit everything online. But I agree with Arthur, if we can do a full service in mainland, then there will be more cases and it will be easier for the mainland parties. So that's all from my end.
One particular challenge, and maybe that's not specific to institutions, but I want to get your thoughts or other thoughts, is to do with all the PRC regulations on cross-border data transfer, because that is an area where lots of people are paying attention to and being quite cautious about. So I like to see what you think are the challenges brought by these regulations.
Oh, thanks, Joanna. Yeah, I think it is a very hot question nowadays. Especially in the past few years, the PRC has tightened its regulation on cross-border data transfer. And there are like various of laws and regulations on this point. And the interesting part is like every few months, there will be maybe new regulations and different departments may have different regulations. But I think to keep it short, nowadays, usually first there are some kind of like information usually the parties need to pay special attention to when they're doing a case. One is the state secret. It has a very restrictions on transferring state secret information. And second is personal information. And third is the data of some special industries, such as the human genetics resources data or automobile industry. And third is about the critical information infrastructures operators. There are some specific rules on those operators like DD, those kind of information service providers. And also there are some like catch-all clauses about the important data in various laws. But I think put it in short, maybe the most relevant law for us is the data security law. It provides that any organization or individuals in China must obtain the approval of the competent authority when dealing with cross-border data submission requests made by foreign judicial.
I think we just lost Chi there. But I think the main takeaway with that comment is the data security law would be the most relevant one, and watch out for the traps and the various sensitive data. If you need to transfer those, there are requirements that one needs to comply with. Oh, we've got you
think-
back, Chi.
Yeah. I think maybe because this topic is interesting, so I lost my computer is too excited. Yeah. So back to the data security law. I think this is one of the most important law we will look at when we dealing with cross-border data transfer. And the key point is how to interpret the definition of foreign judicial or law enforcement authorities. And now the common understanding is that if we are doing a foreign litigation or government investigation, like DOJ investigation, then this clause shall apply. And at least you should do some self-assessment. And you may want to check with the authority whether you need to submit the data to them for approval. But in practice, it is like case by case. For some commercial cases, maybe you don't need to go through the authority, but it is really case by case. And but for arbitrations, there are some like disputes. A very narrow interpretation is the tribunal is not the foreign judicial authority. So for the arbitration, you don't need to go through the authorities, and you just submit the data. But if it includes some very sensitive information, like the state secret or sensitive personal information, then you may want to do a self-assessment and do some redaction. So basically, this is what is the current more prevalent understanding of this clause. But of course, if you are in some very special industry, you may want to refer to some specific clauses as well.
Thank you, Chi. I'll turn to something slightly different now on the next slide, although this is also something Chi touched on just now, which is the doctrine of competence, and the possibility of jurisdictional challenges. Jade, if we can go on to the next slide. Yes, thank you. So as Chi mentioned earlier, the current position is that if a party to, say, a mainland China seated arbitration wants to challenge the validity of the arbitration agreement or the jurisdiction of the tribunal, what they would do is that they would have to apply to the mainland Chinese courts. What we show here on the slide is Article 28 of these proposed revisions, which now provide for the possibility of a party of making such an application to the arbitral tribunal. So it's no longer something that's reserved just for the Chinese courts. Let me turn to Xianglin now to get your views on this. What do you think about this proposed revisions, and what changes do you think it will bring in terms of efficiency of arbitration proceedings?
Thanks, John. Thanks for raising this question to me. Actually, I think this question is related to a very important doctrine, just as Chi touched on, and you mentioned is the doctrine of competence and the competence. As you know, competence and the competence doctrine is universal doctrine to decide the allocation of competence between arbitral tribunal and court. So under this doctrine, an arbitral tribunal presumptively possesses jurisdiction to consider and decide on its own jurisdiction. So this doctrine is widely accepted in international arbitration legislation, judicial decisions, and other authorities. But for some other reasons, actually, this doctrine has not been adopted by the Chinese arbitration law so far. Actually, under the present arbitration law, I note that actually the Article 20 provides that if the parties, object to validity of an arbitration agreement or on jurisdiction of a case, and then the party have two options. The first one is they can apply to an arbitration commission, arbitration institution, not the arbitration tribunal, arbitral institution for a decision. And this is the first option. And the second option is they can apply the objection to a PRC court, a competent PRC court for a ruling. So if one of the parties requests, initiate the litigation proceedings and a request for a decision from the PRC court, while the other party requests for a decision from the arbitration commissions, arbitration institutions, then under these circumstances, the PRC court proceedings will prevail, which means that the arbitration proceedings shall be delayed, shall be suspended until the PRC courts make a final decision on the objection. So this is the provisions under the current arbitration law. So under these circumstances, since the arbitration proceedings has to be suspended until the court proceedings, have a final decision, and then which causes that the arbitration proceedings will be delayed significantly, especially considering that there's like a cases explosion before the PRC courts, and especially under the COVID-19 situation. So the speed for PRC courts to handle civil cases is a little bit comparatively quite slow. So which will definitely decreases the efficiency of arbitration proceedings. But as you mentioned, the proposed provisions of the arbitration law seems that the Chinese lawmakers would like to make a big change on this issue and try to make the arbitration law of China more consistent with the normal practice in the international arbitration. That is, they would like to adopt the doctrine of competence, and the competence absorb this doctrine into the Chinese arbitration law. So as you can see from this slide, the proposed provisions to the arbitration law has made some specific changes in order to fit the common practice in international arbitration. First, the power of determining jurisdiction, determine validity of arbitration agreement, as clearly expressly belongs to tribunal. It belongs to the actual tribunal, not arbitration commission. I think there's a big difference between arbitration institution and arbitration tribunal under the arbitration law, and the power does not belong to court anymore. So specifically, as you can see, Article 28 of the proposed provisions allows the arbitration tribunal to hear challenges to the on the validity of arbitration agreement or to jurisdiction of arbitral tribunal. So if the challenge was made before the arbitral tribunal, if the challenge was raised before applied to the constitution of the arbitral tribunal, and then the arbitration institution will make a decision based upon a prima facie evidence. So based on a prima facie basis, if the arbitration institution believes that this case can proceed, and believes that based upon prima facie evidence, the arbitration institution has jurisdiction on this case, and then the proceeding will go ahead and without any delay. And after the constitution of the tribunal, and then if parties have any objection on the jurisdiction and on the validity of arbitration agreement, then the parties can apply such kind of objection directly to the tribunal, and the tribunal has the competence to decide this issue. So under these proposed provisions, the parties cannot apply such kind of objection to the court anymore. So after the tribunal made their decision on the jurisdiction challenge or on the validity of arbitration agreement. And then if any party has a different view, has objection on this decision, then they can apply to the court for review. I think this review is just subject to first instance, which means that once the court make a decision after the court make a review on the decision of the tribunal has made, and then this decision is final. Sorry, after the PRC court make a decision after reviewing the tribunal's decision, and I think according to the proposed divisions, the party can further appeal this court's decision to the superior court. But anyway, these are courts review process definitely does not affect the conduct of arbitration proceedings, which means that as long as the arbitral tribunal makes its own decision that the tribunal has a jurisdiction on this case, and then despite parties has objection on it or not, and then the arbitration proceedings will proceed without any delay. So under these proposed provisions, definitely the arbitration proceedings will go more smoothly and go more efficiently. So in response to your question, I think this question, these changes, under this issue, I think is definitely just to show a positive signal, showing that the Chinese lawmakers would like to make the arbitration law of China more consistent with the normal practice in the international arbitration. Will definitely increase the efficiency of the arbitration proceedings.
That's really great. Thank you. That's really great to hear, because I think all of us must have encountered situations where one party simply brings in a meritorious jurisdictional challenge in order to delay things or get the proceedings stayed. And hopefully, if this draft amendment comes into effect, it would mean that these sorts of meritorious jurisdictional challenges would also become less frequent, because it seems like from this provision, even if the question is being reviewed, there's a much lower chance of it holding up the conduct of the arbitration proceedings. So very encouraging to see, I think.
Yeah.
Turning to the next topic on the next slide. We're turning to interim relief and emergency arbitrators, but starting with interim relief first, because again, maybe a bit similar to what we touched on earlier in the past, the granting of interim measures in mainland China is something for the mainland Chinese courts, but it seems that with the proposed revisions, there is now the possibility for arbitral tribunals to grant interim measures. I'll turn to Ran now to share some thoughts on what you think about these proposed revisions on interim relief.
Yeah, thanks, Joanne. I think you have mentioned the most significant change with respect to the interim relief mechanism under the proposed amendments, that the arbitral tribunals and even the emergency arbitrators are now empowered to grant interim relief measures to the parties directly. So under the current regime, this power, as you have mentioned, that has been exclusively reserved to the PRC courts. So this means that the parties, if they want to have a interim relief application, they must do it separately in a court proceeding. And that means that at least you need to do another round of preparation for materials, a separate preparation set of materials to be submitted to the court. And some people may think that that doesn't matter, it's just a copy and paste. But actually on the PRC law, it will trigger some tricky and very burdensome requirements sometimes. Like if you are a non-PRC party, you want to have a application for interim relief before a PRC court, you have to have your certificate of incorporations or other identity documents notarized and legalized. Of course, you can negotiate with judges, but under most circumstances, they will still need that before you can launch the application. And that notarization and legalization process will take several weeks or even months in practice, particularly given the COVID situation. And I believe that practitioners involving in such circumstances, we all believe that it is best to avoid this lengthy process, because the delay in the notarization and legalization process may eventually impact the effectiveness of your overall dispute resolution strategy, particularly the effectiveness of the interim relief measures. But now with this proposed amendment, it is possible that it can just apply in the same arbitration proceeding after the commencement of the arbitration proceeding. Like you have seen here is that the pre-arbitration proceeding, the interim application for the pre-arbitration interim application is still reserved primarily for the court. You cannot do it before an arbitration institution. And in addition to this, even for the application made to the court, I have seen a very interesting change here is that under Article 46 of the proposed amendment, we have highlighted these changes is that you can now apply to a court, the court at the place of the arbitration. So previously under the current regime, we do not have such a concept of place of arbitration or seat of arbitration. So it means that if you want to do the application, you need to go to the court where your respondent's assets is located, or primarily where your respondent is registered. So it means that you probably need to go to a local court that you're not quite familiar with, or if your respondent is a powerful company in the local area, there is also a concern of local protectionism among the parties. But now with these small changes, is that possible that the practitioners will try to concentrate their applications to the courts of several major commercial hubs in the PRC like Beijing, Shanghai, or Shenzhen, where we have the major arbitration institutions are located. And of course, you can also do that directly to the arbitral tribunal. So all of these changes are try to increase the efficiency of the entire interim relief mechanism, as well as to reduce the uncertainty due to the variety in local practice. And in addition to that, probably we can turn to the next page. I start on the proposed amendment. The interim relief measures will include not only the 3 types of preservation orders that you have commonly seen in PRC proceedings, and also included under the PRC civil procedural law, namely the asset preservation orders, the conduct preservation, as well as the evidence preservation, but also it allows other short-term measures that the tribunal consider as appropriate to render. But the law has not defined what these other interim short-term measures mean. So it could open a door for much possibility and creativity of the arbitral tribunal. And with respect to the standards of granting these interim relief measures, the standards under the proposed amendment largely resemble those currently under the PRC civil procedural law, meaning that for asset preservation and conduct preservation, the primary factor you need to consider is whether without such measures, the enforcement of the final award will face some difficulties or the parties' interests will be otherwise damaged. And for the evidence preservation, the primary factor is that whether the evidence will be lost or otherwise unavailable if such an application is not granted. So these are quite simple and streamlined factors to consider. And we all notice that in some other international arbitration proceedings, like for the proceedings under the HK45 rules, the tribunal is also requested to consider some additional and more complex tests, such as to balance the interests of the requesting party against the interest of the party that is going to be subject to the interim relief orders, and also to consider whether there is a reasonable possibility for the requesting party to eventually succeed on the merits of the case. So these are more balancing tests and more complex conditions for granting the interim relief measures, but we have seen that the proposed amendment does not include them. So it will up to see whether, well, after the tribunal has been granted such power by the revision of the arbitration law, whether like major arbitration institutions in the PRC like CTEC or the other institutions will revise their rules to include similar factors like under the HK45 rules, and whether those additional factors will be compatible with the current proposed revisions to the arbitration law. These are all the open questions that need to be further discussed, I guess, during this the entire legislative process. And finally, as to some practical complexity regarding the enforcement of these interim relief measures granted by the arbitral tribunal, I guess the effectiveness of these measures will largely depend on whether the court will be able to enforce it, because under the current power allocation in the PRC, the arbitral institutions and arbitral tribunals simply do not have the sufficient power to enforce their orders. So the parties have to rely on the court to do that. And actually the proposed amendment has considered this and has set different rules for different types of interim relief measures we have just discussed about. For those preservation orders, which are commonly seen, which have already been included in the PRC civil law procedure, that means that the law has already granted the court a clear path to enforce them, that the court shall, at least according to the text, the court shall enforce the interim relief measure in the forms of these three types of preservation orders, in accordance with the relevant provisions of law. Now, one challenge is that even though with a clear legal rules, the practitioners have seen in reality it would be quite difficult to get and enforce the conduct preservation. At least it would be very challenging outside of the context of intellectual property disputes. So whether these revisions in arbitration law will change this picture is a huge question mark. Whether the court will be willing to innovate their current measures or current practice to accommodate the various creative approaches adopted by the tribunal in their interim relief measures will need to be tested further in practice. And particularly as to the other short-term measures we have talked about that has been introduced but not defined, they are not, that it is not a category under the PRC civil procedural law. The proposed amendment has given the court a huge discretion over whether the court will enforce such short-term measures. The court will only enforce when it believes such enforcement is feasible, and this will be fully open to the court's own discretion. Of course, we will all be watching whether the Supreme People's Court will revise their judicial interpretations or add some judicial interpretations to enforce this or further clarify the standards they are going to take for this provision. But at this stage, it's still unclear whether this creative arrangement will be really put into practice. And we believe that in early stage of the enforcement, you will see a lot of confusions and a lot of efforts to try to clarify what the rules really mean and how the court will really do in practice.
Thank you, Ran. I see that we have some audience questions too in relation to powers to collect evidence. We still have a couple more slides to finish, so maybe let's turn to those first, and hopefully we have some time at the end to address that. So on the next slide, just briefly, before we finish up on this topic, let me ask Chi her thoughts on emergency arbitrator, because I guess similar to interim measures, there could be situations where parties want urgent relief, urgent measures before the constitution of the tribunal. Some rules already provide for that, but Chi, could you comment on this new provision in relation to the emergency arbitrator appointment?
Sure, and given the time, I will give a very quick comment. So currently, this is a new provision, and this is the first time the arbitration law introducing the emergency arbitrator provision. And now, currently, although there's no such provision, but in practice, there are many domestic PRC institutions. They have rules having emergency arbitration provisions. For example, CTEC, BAC, or Shanghai Arbitration Centers, they all have emergency arbitrator provisions. But however, because currently the emergency arbitrator's ruling is not enforceable in mainland China, so in practice, the parties, they seldom choose this mechanism. And I imagine after the adoption of the arbitration laws, and given that now the tribunal can held on their own jurisdiction and have the court to enforce their decision. So I think there will be more and more case the parties can use the emergency arbitration mechanism. But currently there are few cases in the news about the emergency arbitrators. They are all cases either the seat of arbitration is outside of mainland China, or the parties will enforce the emergency arbitrators award in the foreign jurisdictions, such as Hong Kong. For example, in 2017, there is the first emergency arbitration case in mainland. It is at BAC, the Beijing Arbitration Institution. And in that case, the emergency arbitrator issued an award to freeze the respondent's assets and also order the respondent cannot use others or encourage others to transfer its assets. And then the claimant enforced this emergency arbitrators award in Hong Kong. So this and also this order was issued within 11 days, so it is quite efficient. And I imagine that after adoption of this clause, and there will be more and more cases using this mechanism, and this mechanism will be more powerful in the domestic arbitrations as well.
Thanks, Chi. I think that's always been the problem with emergency arbitrator measures. Like if you have a counterparty who voluntarily complies with it, that's great. But if you have to, at the end of the day, seek enforcement, and if it can't be enforced, say in mainland China, and your counterparty is in mainland China, that's always an issue. So with this proposed revision, hopefully things will change. I think we can stop sharing the slides now, because the next topic we turn to is enforcement. And I'm going to turn back to Arthur, because I know the proposed revisions, there are some updates here and there on enforcement, but it might be fair to say it's not a major overhaul on the enforcement regime. But it's a question that always comes up. So I also want to just get your insights on how do you see the current enforcement regime? Any observations on how effective it is right now?
Oh, thank you for the question. I'm aware of the time constraint. I'll be quick. First of all, I think the current enforcement, arbitral award enforcement mechanism is quite clear under PRC law. We have, for example, civil procedure law to handle domestic awards. We have a New York Convention as part of PRC law to handle New York Convention awards. We have the arrangement with Hong Kong, with Macau, to handle the enforcement of awards seated in these jurisdictions. So you can say 99% of the cases you can find a clear legal basis in PRC law to have a competent court to accept the case and to enforce it. But that is the law. As we say, the idea is very full, the reality is very skeleton. As to whether you can really have the award successfully enforced, that is entirely a different case. Because, and I have to make a clarification. For many of my clients, sometimes they blame that, the legal system is not very competent, the court is not very helpful because we can't collect the money at the end of the day. But I have to make a clear distinguishment between collection and enforcement. The court of PRC, in most of my cases, they're quite supportive, but their capacity is bound by the PRC law procedures. They can do what the law allow them to do, but they cannot guarantee they can get your money back. At the end of the day, it's part of your commercial risk. If you cannot collect, for example, some respondent losing side, they're running really out of money, they're bankrupted, insolvent. They have a line of debtors in front of you. You're the third in the queue, or maybe you're the 15th in the queue. And at the end of the day, you don't have any money. And the court will say, too bad, so sad. The proceeding will have to close until and unless you tell us where the enforceable assets are. That's a reality. And in many of my cases, seriously, that's the end of the story. Very sorry after so many years of fighting. But is that a part of a problem of the PRC court system? Is that a defect in the legislation? I would not say that. That you have exhausted, and also the courts they have exhausted all the legal measures, and the remedy is not available, but that is a reality. So again, I guess many of the colleagues would join me in that if you are really chasing for the money before you raise the arbitration, make sure at least you can find some enforceable assets. Otherwise, perhaps at the end of the day, the arbitration proceeding is futile. Never helpful. Yeah.
Yeah, I think that's an insightful observation. And when we discuss with different people, often one question you need to ask yourself before you bring in arbitration is, if the other side hasn't paid you yet, is it because they are refusing to pay? They have the money, but they are simply not willing to pay? Or is it the case that the reality is that they simply do not have the money to pay you?
Exactly.
Because in the former situation, if they're simply refusing to pay, there may be tactics you can use. You can bring them to the table with different legal measures you can try and deploy. But if it's the latter situation, then as Arthur say, it's a commercial situation, then it's a good idea to do some proper asset searches before bringing on formal proceedings. I see that we're running out of time, but just very quickly back to Ran. I know these are simply proposed revisions now. Could you just give a brief sense to our audience as to what the next steps would be before it becomes enacted law?
Sorry, that question addressed me?
To Chen Ran.
Okay.
Thanks, Joel. I guess the thing is that that is still on the current process, like under the State Council. Like the draft was circulated by the Ministry of Justice, which is on the State Council. So basically, under the PRC legislative process after the State Council level, they will present the bill to the National People's Congress. In our case, will be the Standing Committee of the National People's Congress, and there will be 3 readings for the bill before it can be put on for vote. And after that, a simple majority of votes will sanction the bill into the law and to be signed by the president. But at this stage, we've just seen a legislative plan released by the State Council last month for this year, is that the proposed amendments for the arbitration law is still under preparation for the submission to the Standing Committee, meaning that it is probably will not be submitted to the Standing Committee of the National People's Congress this year. So, and given that the NPC will still need several months, at least for 3 readings, we probably will not see it into effect very soon. Definitely not this year, if everything goes as the plan says. But on the other side is that I see that the proposed amendment has already shown that China's willingness to be arbitration friendly and to open the market. And I guess even though they have not been put into the law, the spirit is here. And during this period of changes, perhaps the court system and the other relevant authorities will also uphold this spirit in their daily activities, particularly in all the cases related to the arbitration, like the validity of the agreements or the enforcement of awards. So I think overall, this will still be a very good guidance for all the practitioners to see what will be the future of the PRC arbitration practice.
Thank you. So I think we can end on that positive note. It's still some way to go before it becomes an enacted law, but as Ryan said, these are all positive signs. So I think we can all watch this space and see how this develops. Let me say a big thanks again to our speakers today, Ran, Xianglin, Qi, and Arthur. Thank you very much for joining us. And also a big thank you to all the participants for dialing in today, and HKIAC for hosting this for us. Thank you very much and hope to see you all again at our other HK45 events. Thank you.
Thank you. Bye-bye.
Thank you.
Thank you, John. Bye-bye.
Bye. Have a good day.
Bye.